Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. The Jharkhand High Court today granted bail to former Chief Minister Hemant Soren in the alleged money laundering case involving illegal possession of 8.36 acres of land. Soren was arrested in January this year after resigning as Jharkhand Chief Minister. His arrest was followed by his failure to respond to 8 out of 10 Enforcement Directorate summons. The agency questioned him 3 times starting in November 2021 in connection with an alleged illegal mining case. ED's investigation uncovered the illegal sale and purchase of another 8-acre land parcel in Ranchi's Bargai area. The bench of Justice Rangoon Mukhopadhyay observed that there was no evidence directly linking Soren to the possession of the land in question and that ED's statements that their intervention prevented illegal possession of the land were ambiguous. The court further observed that in this case, the twin conditions under Section 45 of PMLA had been satisfied and hence Soren had to be released. If you remember, the Supreme Court had earlier refused to consider Soren's plea for interim bail. The Supreme Court has extended the interim bail of BSP leader and former MLA Uday Bhan Singh, who was convicted in a murder case. The matter pertains to MLA Singh's conviction in a criminal case from the year 1999 for murdering 3 persons along with 10 other co-accused by the trial court. Singh was sentenced to life imprisonment and has currently undergone actual custody of 20 years and 7 months. The top court has also issued notice to his contempt petition alleging inaction by the state authorities against the order directing his premature release. The vacation bench of Justices A.S. Oak and Asanuddin Amanullah was hearing a contempt petition filed by Singh against the Principal Secretary, Department of Home Secretariat, Uttar Pradesh, in violation of an earlier order of the court which allowed for premature release of the MLA. The bench, while issuing notice, directed the Principal Secretary to comply immediately and pass orders according to the directions of the court on April 29th. As per this order of April 29th, the writ petition for premature release of the MLA was allowed by the top court. The court granted the benefit of parity to the MLA as 3 of the co-accused had already been granted premature release. The state authorities were directed to dispose of his application for release within a period of 6 weeks from the date of the order. In the next update, a petition seeking issuance of specific directions to immediately constitute an expert committee for assessing and identifying the viability of the 3 new criminal laws has been filed before the Supreme Court. In addition, the petition also prayed for a stay on the operation and implementation of the 3 new criminal laws, which are scheduled to come into effect from 1st July. The petitioners argue that the titles of the current laws are not accurate. The petitioners state that the bills were passed without any proper parliamentary debate as most MPs were under suspension. It added that the introduction of new criminal laws can impact lawyers by increasing their workload, adding complexity and ambiguity to legal provisions, and necessitating additional continuing legal education. Lawyers may face resource constraints, procedural changes, heightened scrutiny, and potential restrictions on advocacy, affecting their ability to provide effective legal representation. Apart from this, the petitioners contend that there are discrepancies in the acts. For example, the Bharatiya Sakshya Adhiniyam, which is to replace the Evidence Act, provides for the admissibility of electronic records, but it lacks safeguards to prevent tampering and contamination of these records during the investigation process. Moreover, the new criminal bills do not introduce substantial changes from the previous ones, creating confusion among citizens and granting more power to the police, potentially suppressing fundamental rights. Well, this is not the first petition before the top court in this matter. Earlier, the court has refused to entertain PIL challenging the new criminal laws, saying that the laws were not in force. Stay tuned with Live Law to know more on this. The Andhra Pradesh High Court has stayed the demolition notice issued to 10 YSRCP party offices across the state. Earlier this week, the municipal corporations 10 districts issued demolition notices on the semi-constructed YSRCP party offices. Following this, a series of petitions were filed before the High Court praying to quash the notice on the grounds of being arbitrary, illegal, and issued without jurisdiction. It was argued that there was no rationale to demolish the construction without even attempting to regularize it. It was vehemently reiterated that demolishing a building cannot be authorized for minor irregularities and should only be imposed as a last resort. The Advocate General, appearing on behalf of the state, argued that the issuance of a demolition notice was indicative of the due procedure being followed. Now, Justice B. Krishna Mohan, hearing the arguments, has reserved the cases for the pronouncement of orders and extended the interim stay on notice to all the petitioners till the pronouncement of the judgment. The Jharkhand High Court has ordered the state government to pay 5 lakhs in compensation for illegally demolishing a privately owned building that housed 5 shops. Additionally, the court has directed the state to pay 25,000 for the mental pain and agony suffered by the shop owner due to the state's high-handed actions. In 2011, the district administration demolished the petitioners' 5 shops without following due legal procedures, issuing notices, or obtaining a court order. This prompted the petitioner to seek relief from the High Court, arguing that the district administration had unlawfully bulldozed his shops. In response, the state contended that the structures were illegal encroachments and that the petitioner had no rightful claim to the land. After considering both sides, the court has ruled in favor of the petitioner, ordering the state to compensate him for the reconstruction of his demolished property and the mental distress he suffered. Justice Dwivedi thus opined that the action of the authority was illegal and violative of all principles of rule of law, which has certainly caused mental pain and injury to the petitioner, besides material damages to his property. And lastly, a lawyer has moved the Kerala High Court against dumping of garbage and plastic waste in forest areas, national parks, wildlife sanctuaries, and tiger reserves in the state. The petitioner is aggrieved by the inaction of authorities in combating plastic pollution in ecologically sensitive and forest areas to prevent environmental pollution. In his public interest litigation, the petitioner alleged that most of the accumulated waste consisted of single-use plastics, PET bottles, and packages of snacks and beverages. He alleged that dumping such waste into sensitive ecosystems and forest areas, especially by tourists, endangers the rare flora and fauna. The plea stated that no measures have been taken to remove or recycle plastic waste in Kerala despite the growing issue of plastic pollution. The plea thus seeks issuance of appropriate orders from the state government. It also seeks formulation of a permanent scheme to remove accumulated plastic waste from forest areas, national parks, and tiger reserves in the state in a time-bound manner. The petition was heard by the division bench comprising Chief Justice A.J. Desai and Justice V.G. Arun, which has issued notice to the state government. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.